Good morning, commissioners. I'm Carrie Batha. I'm an environmental scientist with our statewide planning unit. I'm here to introduce item 6D, which is an informational briefing on a report by Dr. Charles Lester called Protecting Public Trust Resources in the Face of Sea Level Rise. Like Jack said, we have Dr. Lester here with us today to give an overview of the report, but first I'm going to give a little more background on the interagency work we've been doing with State Lands Commission staff that gave rise to this report. So interagency collaboration has always been a key part of the Coastal Commission's program. The State Lands Commission manages public trust lands, including coastal tidelands, on behalf of the citizens of California. And the public trust doctrine establishes that the government holds sovereign title to certain submerged lands and must protect them and their resources for public uses, like public access, recreation, commerce, navigation, fishing, boating, and environmental preservation, all of which are also prioritized and protected under the Coastal Act. So with our overlapping jurisdictions and mandates along the California coast, coordination between our two agencies has always been critical, especially when thinking about issues of statewide concern like sea level rise. Recognizing this, the Coastal Commission strategic plan includes a task to coordinate with State Lands Commission on sea level rise. And we recently received Section 309 funding for this work from NOAA. In 2017, our two agency staffs began a concerted effort to develop a framework for interagency coordination. And in 2019, we signed an MOU outlining processes for early and thorough communication between staffs. The interagency team has also been working on several other resources and best practices, including background documents to educate agency staffs about how our agency's roles intersect, case studies of locations along the coast where development and sea level rise could impact public trust resources, and technical resources like a mapping platform that allows staffs to view active permit and lease applications. We also engaged Dr. Charles Lester as a consultant to write a report on how the agencies can continue to protect public trust tideland resources in the face of sea level rise, which he's about to review for you. His recommendations are his own independent conclusions informed by an extensive career in and deep understanding of coastal policy and management. Going forward, our team plans to analyze Dr. Lester's recommendations alongside the rest of the work that we've done so far and critically synthesize it into an action plan with the various research priorities and tasks that we plan to work on in the future. And this plan will come back before the commission at a later date for adoption. So with that, I'm going to quickly turn it over to Maren Farnham, who's a senior environmental scientist from the State Lands Commission, for a few remarks before Dr. Lester speaks. And after that, we'll all be available for questions and discussion. So Maren, you can go ahead and unmute.
Thanks, Carrie, and thank you, commissioners, for having me here today. Just to reiterate what Carrie said, we really do value this interagency coordination and the opportunity to come before this commission to demonstrate our commitment to the really valuable work that we're doing together. Like the Coastal Commission, the State Lands Commission strategic plan includes commitments to interagency partnerships to advance the legal and policy frameworks needed for climate resiliency. This partnership has been critical to achieving that goal and has also led to a greater level of coordination between our two agencies than ever before. And it's really strengthening our coastal resource management practices and decisions to protect the public trust. We look forward to working with the Coastal Commission staff to develop an action plan for our work moving forward based on all the work we've been doing together so far, and really rooted in the work that you're going to hear about now from Dr. Lester. So Charles, we'll turn it over to you. Thanks so much.
Thank you, Maren, and thanks, Carrie. Good morning, Chair Brownsy, commissioners, and thank you, Jack, for the introduction. I want to begin by thanking you for the invitation to talk about this issue that is so important to the future of our coast. I know you have a busy calendar, so I'm just going to jump right in. Next slide, please. As Carrie mentioned, the report addresses the public trust doctrine, which dates back to Roman law. And this is the idea that the seashore or tidelands are common to all of us, but we share them in common ownership. Slide. Through the common law, this idea has evolved to a doctrine that the public has a right to use tidelands, those lands understood to be between the mean low and high tides, for various public interests such as commerce, navigation, fishing, recreation, and wildlife preservation. So this report is focused on the protection of these tideland interests in the face of sea level rise. Slide. So what do we need to think about as this public space moves inland with sea level rise? Slide. In particular, how should we deal with the inevitable challenges that you're going to face with shoreline development immediately adjacent to tidelands, places like Solana Beach, Santa Cruz County, Malibu, Stinson Beach, Ventura County? You know the places. Next slide, please. So to begin, this is not new ground for the Commission. And in fact, the concern for protecting the public trust was identified in the Coastal Plan in 1975. And in 1977, the Commission articulated through its first interpretive guidelines the idea that development should not be approved if it was inconsistent with the public trust. Next slide. In the 1990s, the Commission played a central role in firmly establishing in California that the mean high tide is ambulatory, more on that in a minute, through its review and litigation of a proposal to build 17 houses, a road, and a seawall on Lechuza Beach in Malibu. Next slide. Over the decades, the Commission has often evaluated potential development impacts on tidelands, such as the Geffen case in 2000, where the Commission not only asked if development was inland of the most inland known occurrence of the mean high tide, but it also identified future sea level rise as one of the reasons to do so. Imagine that, that was over 20 years ago. Next slide, please. Of course, most recently, the Commission has started to build concern for public tidelands into its conditions by identifying the migration of tidelands due to sea level rise and the related possible private encroachment onto public trust lands as a trigger for potential future removal of the development. There are at least a half dozen cases on the agenda this week that raise this issue. Next slide. So you have a long history and practice of concern for the protection of tidelands, but sea level rise really elevates this concern. And because of this, the report has set out a number of recommendations that speak to firmly embracing your affirmative duty to protect tidelands by, for example, developing interpretive guidelines, working on shared principles with your agency partners, and updating LCPs. I understand you have quite a bit of funding to do that. Next slide. A second set of recommendations relate to this idea, again, not new, that tidelands are ambulatory, but revisiting it in light of sea level rise. So we know that the mean high tide line ebbs and flows with the intersection of the mean sea level with a changing shoreline. On the left of this slide, for example, we see a range of shorelines in La Jolla that were determined by the USGS. On the lower right, you can see a picture of the recent State Lands Commission surveys from Hollister Ranch, where the mean high tide line shifted 60 feet inland in less than 2 months. Next slide. We also know from recent scientific assessments and modeling, like the application of the Cosmos modeling tool, that the shoreline is projected to generally move inland with sea level rise, such as this shown by a projection in Del Mar, identifying perhaps 137 feet of possible movement with 100 centimeters of sea level rise. Next slide. Here's another example from Sandyland in Carpinteria. I'm sure Jack knows that case, where, if not prevented from doing so, the shoreline might migrate well inland of the existing development with 2 meters of sea level rise. Next slide. That said, there's also considerable uncertainty in our sea level rise models the further out in time we go. So we need to be concerned about the potential range of future tideland locations. This slide depicts what this range might look like in Oxnard on the left and Laguna Beach on the right. Next slide. So that recognition is the basis for a second set of recommendations that embrace the dynamic reality of tidelands and suggest focusing not on the identification of a fixed mean high tide line, but rather on an ambulatory zone of concern within which we need to be concerned about future public trust resources. Recommendations include such things as using the best available science to identify the current and project the future location of this tideland zone of concern, and updating your permit filing requirements to assure that you have sufficient information to address this reality. Next slide. A third set of recommendations speak to the fact that shoreline development, particularly shoreline structures, can have hugely significant impacts on tidelands, something that you all know all too well, through such things as encroachment, displacement, interfering with public access, and passive erosion, which may result in the eventual complete submergence of tidelands due to the coastal squeeze. Next slide. We also know that there are nearly 1,500 lateral public access easements that have been required over the decades. The vast majority of these tied to the mean high tide line. So we are facing the potential loss of significant public access as the seaward edge of these easements moves inland. On the other hand, we also face some interesting future challenges in cases where the easements by their terms are entirely ambulatory, such as the example from Broad Beach on the right. The recorded easement notes that both its seaward and inland edge are ambulatory. So I'm glad I won't be dealing with that one, Jack. Next slide. More broadly, how are we to deal with the migration of public tidelands on or into upland development that is often private? There's a federal case out of the state of Washington, the Milner case, where the Army Corps of Engineers brought an action for trespass against a private revetment protecting a residential property. So identified in the middle of the slide there. The court applied the common law principles of the public trust to explain that both the upland and the tideland owners had a right to this ambulatory boundary. But because of that, the upland owner did not have a right to permanently fix the tideland boundary with the revetment, absent agreement from the tideland owners. Next slide. So a third set of recommendations speak to things you might do to anticipate future conflicts between public tidelands and private uplands, and ways to avoid the loss of tidelands by, for example, following the principle of the Milner case, or by refining your use of rolling easements, and by interpreting Coastal Act 30235 as but one of many Coastal Act Chapter 3 mandates that may sometimes conflict with each other. So in order to better address proposed shoreline structure development, consider that kind of interpretation. At bottom, though, under the legal rules, the critical question for you is simply whether there is an impact to a public trust resource. Next slide. Related to development impacts, another set of recommendations focus on the reality that we are already seeing significant development on tidelands, but that we probably don't understand its extent. For example, we know there are clusters of shoreline structured developments on tidelands simply by looking at the State Lands Commission database, which is great, by the way, such as these clusters in Solana Beach and the Malibu shoreline. Next slide. Here's a simple example of a tideland lease area for the Surf Song seawall in Solana Beach, where the homeowners are paying about $24,000 a year for their incursion onto tidelands. Now, this is not necessarily a problem with the public trust doctrine, as the state can allow trust lands to be used, but only so long as there is not a substantial impairment of the public interest. Next slide. But sea level rise, in my view, really begs this question. At what point will shoreline development be a substantial impairment? Are the steadily increasing string of seawalls in Solana Beach a substantial impairment? If the tidelands get squeezed out by sea level rise, at what point is that a substantial impairment? If not now, when? Next slide. Therefore, there is really a need to dig into the coordination efforts that you heard about earlier today between the Coastal Commission, the State Lands Commission, in order to better identify all of the places where this may already be or will increasingly become a concern. This also heightens the need to work on policy and impact mitigation coordination, monitoring, and possible enforcement. Next slide. Finally, there are a set of what we might call technical or methods recommendations that address, for example, the potential use of new technology such as LiDAR and drone surveying to enable more contemporaneous identification of a tideland zone of concern, or using updated methods of calculating the mean high tide elevation to better address the reality of rising sea levels. Next slide. So let me close by returning to the big picture of protecting tidelands access. You probably know that in the Nolan case out of Ventura County, the commission was concerned in part with the direct and cumulative impact of the development on the ability of citizens to access tidelands. Next slide. And therefore, in that case, you required a lateral access deed restriction to provide a public right of pass and repass. Next slide. But you probably also know that the US Supreme Court threw out this condition for lacking a nexus to legitimate state interests. There are many legal and policy dimension aspects to this case that I won't go into, but I find it interesting that Justice Brennan's dissent specifically refers to the shifting character of the tidelands as a very good reason to protect this shoreline zone between the mean high tide line and the development for public access. Next slide. And it seems to me that our increasingly sophisticated projections of sea level rise, we need to get back to this idea of protecting the public tideland space to the maximum extent possible. Next slide. And we can see that today, for example, if we project sea level rise at the Nolan site, if the shoreline was allowed to migrate inland, it would be well into the site of the Nolan house, maybe even by 2050, meaning we stand to lose our tidelands at this location potentially very soon. Next slide. And this is not simply a hypothetical, as we only need to look at conditions today during a king tide to see what the future might hold for tidelands along this stretch of coast. In fact, this is a growing reality, as you know, for much of our coast. Next slide. So that brings me to a final point, which is, I believe, the heart of the public trust doctrine is really about justice. In this case, the environmental justice concerns of how we protect tidelands for the literally millions of Californians that hold an interest in these trust lands, especially those that are not able to live along or in close proximity to, or perhaps even visit the coast. So both you and the State Lands Commission have identified sea level rise in the public trust as raising EJ concerns, and these should continue to drive your efforts to protect tidelands. Next slide. And so we return to the beginning, when nearly 50 years ago, Californians declared that the coastal zone belonged to all of the people and that its protection was a paramount concern to not only present, but future generations. So this challenge of sea level rise is huge, but we must take it on to the best of our abilities. And I hope that the work of this report will be helpful in that regard. Thank you.
Yeah, Madam Chair, I just